Now, my story today comes out of a federal court in Massachusetts where four cannabis companies have sued Merrick Garland and directly challenge the case of Raich versus Gonzalez from 2005. Now, what happened in court was predictable, and they got their case dismissed, but the court found they had standing to bring it. They just were not going to overturn Raich at a trial court level. And what it looks like is they went shopping for the right circumstance, the right forum, and they went in directly after Raich, and they expected to get dismissed at the trial level. And I'm hoping that they put in all the evidence they needed to challenge Raich on all four corners as they go up the ladder through the appellate courts. And this may be that case I've been talking about, that if it gets in front of the Supreme Court and we haven't had other action taken on cannabis in the Controlled Substances Act, this could overturn Raich. Now, one of the problems that we face in this industry right now is based in Raich, which was the 2005 case where Angel was going to grow it in her backyard and use it in her house, and the court dusted off this 50, 60-year-old case from the New Deal era that gave the federal government Commerce Clause authority to regulate non-commercial intrastate activity. Now, under our Constitution, the Commerce Clause allows Congress to regulate commerce amongst the several states. I don't care how you torture that word, it's not non-commerce inside a state. Okay? So what they did in Wickard versus Filburn way back in 1942 was a very progressive court allowed the federal government on the Commerce Clause to get into your personal business under Commerce Clause authority. And that has been the law ever since that. Now, right now, there's a lot of attention in our Supreme Court. A lot of people have their panties in a knot over a conservative majority that's 6-3 right now. And people are finally beginning to pay attention to the political nature of our Supreme Court. What is happening is the pendulum is swinging back the period before the New Deal, back during FDR, when the nation was really starving and they were afraid people were going to go to the streets and overturn everything. So they began to pass legislation and stretch areas of federal law and federal authority on the Constitution. The conservative courts in those days said, no, we're not going to do it. Now, up until FDR won his second term, the Supreme Court was just slapping down all of their New Deal legislation. So you don't have authority for this. You exceeded, the Congress exceeded its authority. The president doesn't have executive authority to this. They were just slapping the shit out of them right and left. But when FDR got reelected, he threatened to pack the court, put in legislation. We're going to increase the court, double it basically. I'm going to get to appoint a whole new court basically. And what they called the four horsemen, the four conservatives, are going to be outnumbered. Well, there was four conservatives and three they called the three musketeers were progressive, and there was two in the middle, and one of them had consistently voted with the conservatives until this court packing thing, and for whatever reason, I don't know, he ever explained or ever understood, he changed his tune and voted to support and started supporting consistently New Deal era legislation. So what happened was very progressive Supreme Court cases came out. Some of them needed to come out, but I'm talking Brown versus Board of Education. There was a lot of others that just needed to be done. But the extension of the Commerce Clause really went a long distance, and it's been reined in a bit since then with like domestic violence and guns. Like there's no Commerce Clause authority for that kind of shit. So Wickard versus Filburn is still out there. And this guy, Filburn, was a farmer. They claimed he grew too much wheat, and he was using it to make his own bread and feed his own cattle instead of that. It's not commercial. It's not going out of the state. And the court said if your cumulative effects of this have a substantial impact on interstate commerce, we're going to allow this, okay? Now, along comes Raich, where they tried to challenge the Commerce Clause authority over marijuana. And the Rage courts dusted this off and said, well, here's authority from way back when to allow us to control intrastate non-commercial activity under the Commerce Clause, okay? And at that point, 2004, 2005, marijuana legalization efforts and decriminalization efforts were nothing like we have today. And I've mentioned many times what Clarence Thomas had to say, and he pulled out the 10th Amendment. He said, this is clearly within the 10th Amendment. The federal government stepped over the line here, and I'm pretty sure with the 6 conservative majority we have right now, we can get that question back in front of the Supreme Court, whether they have Commerce Clause authority, given that it's a higgledy-piggledy now prosecution system across the country, whether this is going to stand up. Now, that is the initial challenge. And as you know, we've got rescheduling to Schedule 3 in the works right now. And you all talked about this new case, the Loper Bright Enterprises that took away the Chevron deference doctrine. Now, what I'm curious about, and we're going to have to watch and see how this happens, is that case, which takes away deference from these administrative agencies, whether that's going to have an impact and in what that impact might be over the DEA and this rescheduling activities here. Because they've just turned the apple cart over. And I don't think anybody really understands how this is going to affect these administrative agencies. The DEA is one of the notorious asshole administrative agencies in our government, especially when it comes to marijuana. They have dragged their feet. They have forced you to go to court to just get approval to take the next step. And right now, we're going back to the what called the Administrative Practices Act, passed just after World War II. And they're going to hold these administrative agencies to only the power they're given directly by Congress, and everything else has to go to the courts. So this is going to be an interesting pathway through marijuana over the next 1 to 2 years. And I don't have any predictions of how it's going to turn out. It's just going to be, an old-fashioned shit show from all different directions. I'm hoping that we can get this question in front of the Thomas Court, or the Roberts Court now, and have the court say, no, the definition of marijuana is not met in Schedule 1, so therefore it's removed from Schedule 1. That'll force the federal government to shit or get off the pot. You got to do something now, and it's going to have to be Congress that does it. It's not going to be an administrative agency. Oh, we're going to start this discussion and continue it along the line. I'm going to throw it back to all of you. What do you think about this nonsense going forward?
So just to give some reference on this, this is the David Boies case that you're referring to, correct, Dale? Yes. And we spoke about this. We did cover this story yesterday also too. But this story is so important. I'm so glad that you covered this today, Dale. So are you telling me that basically because of their decision, and this is probably why the lawyer from Boies' side was not upset with the decision that the judge made, but that now, because of the decisions that they just made, now the Supreme Court could take up this whole new argument, and it would just totally throw cannabis out of the schedule, is what you're telling me.
Well, yeah. And the court is definitely defining the separation of powers in this country right now. That's what the Chevron doctrine being taken away was all about, is that Congress has the power to set the law. And if they give an administrative agency specific instructions on what they're supposed to do with this law, that's going to be allowed through the administrative process. But for everything else that might not have been in the law that's uncertain, you're going to have to take it to real court. Okay, where you have juries and you have judges who will bring in multiple experts.
I'm all about that.
Not let these agencies say, well, our guy says it's this way. After the COVID-19 debacle, I don't think anybody trusts these administrative agencies anymore.
Nope, that's true.
And we're seeing the pendulum swing back to what the court's position was prior to the New Deal, where the court decided the law, the Congress made the laws, and the president's job was to execute the laws. And they're defining that. People are all pissed off about it. I can understand in a lot of ways, but that's where this pendulum is swinging back to.
So it's getting back to our actual roots on how this country was founded, is what you're telling me, Dale.
No, that's not what he's saying. You're spinning.
I love you so much.
I'm sorry. I suffer from truth Tourette's. I'm diagnosed yesterday.
Let you tell it.
So let's talk about those three branches of government and the checks and balances and the concentration of power does pendulum between different branches during different eras of this country. But this exceedingly concentrated power in the federal judiciary that has happened in the most recent period of time is not something that you can look back and say, well, that's always how it's been. Nor can we say that the founding fathers expected the Supreme Court justices to be devoid of ethics requirements, transparency requirements, reporting requirements around gifts provided, or this whole notion that they would be above the law themselves, much less anointing other people as being above the law.
That's your take on it.
I can tell you, Yarrow, that going back to Bush v. Gore, it was really, the bell rung really hard for me that this is a political institution.
Yep.
Are interested in the results, and they will stretch what the Constitution says as far as they need to. And in some instances, that may be okay. In other instances, it's definitely not. We have this thing called the 10th Amendment, and the states and the people, we control all power unless the federal government's specifically given it. And that's where a lot of this needs to go back to.
Yep.
And it's what scares people in reproductive rights, okay? Because we've seen some draconian shit come out of these states. But the substantive due process issue is where we're going to see a lot of battles here. That's basically equity in due process, not procedural, notice and opportunity to be heard. Is there some fundamental right involved here? And they really take their microscopes out to look for fundamental rights. And I think this court is saying, no, those rights that you're arguing are not fundamental in the Constitution. And so we're going to see pendulum swings here in multiple areas. And this is just going to be one. These administrative law judges have way too much to say. About things Congress should be saying about.
I totally agree with that.
Speaking about my pendulum swinging, if you have to take a magnifying glass or a microscope out to see my fundamental rights, then you're looking at the wrong part, wrong side.
You're looking at Vienna.
Yeah, Vienna, not glitzy.
Oh boy, oh boy. Any thoughts on this?
I'm gonna stand up to his Vienna slander. I was just.
It's only slander if it's not true.
All right. Well, I don't have enough data to make that assertion yet. But as a city, I will back up. I will back up and defend Vienna here.
I'm getting a tattoo that says "My glizzy is glitzy," and
I love it.
We'll see who joins me.
I co-sign that.
That's cute. That's cute.
Ain't no Vienna in my sausage.
Oh man, you guys, we got to go to a commercial. We're gonna be right back.